Parenting. What is it? What does it involve? What is the process? What are the different avenues to reach an agreement? I'm Andrew from Folbigg. I'm one of the principals in the Family Law Department. I'm an accredited specialist in family law. Our team consists of 7 solicitors, 4 of which are accredited specialists. In our Family Law Department at Folbigg, we advise clients on various aspects of family law, including but not limited to property, spousal maintenance, child support, and of course, parenting. Parenting matters. Parenting is a substantial branch of family law. It encompasses what happens with your children after separation. In terms of how we document parenting agreements, this can be done in 2 different ways. The first way is by way of court order, and the second way is by way of parenting plan. A parenting order is an order made by the court, either by consent or by a judge after an interim hearing or a final hearing, that deals with where a child is to live, how much time they are to communicate with the other parent, and parental responsibility. On the flip side, a parenting plan is a document such as a parenting order but is not enforceable. A parenting plan is less formal and can be utilised at later hearings when you go to court. What can be documented? Essentially, there are 4 main categories that can be documented in parenting arrangements. That is parental responsibility, time, communication, and ancillary orders. In terms of parental responsibility, this encompasses who should have parental responsibility for your children. Usually there is a presumption of equal shared parental responsibility where both parents have a say in what happens to their children. Flowing from parental responsibility, the court then considers what time should be ordered between parents and their children. Time can either be equal time or substantial time. The difference being that equal time encompasses time on an equal basis, for example 7 nights a fortnight, whereas substantial and significant time, which is the flip side of equal time, can encompass such as 4 to 5 nights a fortnight. In terms of how the court determines what orders to make and how our specialist lawyers at Folbigg will advise you accordingly will depend on what we call the best interest principles. These are a range of principles which we discuss and the judges look at, which are well entrenched in the Family Law Act. Some of the important factors include the age of the child, the nature of the relationship with their parents, the wishes of the child, the capacity of either parent to care and provide for their children, and of course, family violence. Finally, the process. If you come to Folbigg and you have already reached an agreement about your children, we can provide clear, succinct advice about the best way forward. In some circumstances, unfortunately, a court application is necessary. In this situation, it may be advisable for parties to first attend mediation, which is a prerequisite. However, in instances where there are circumstances of urgency or what we call emergency, it may be that an urgent application needs to be made to the court, leaving mediation to one side. Remember, if you have a problem with your children before separation, consult one of our specialist family lawyers at Folbigg.